All right. Good morning, good afternoon, depending on where you may be. I'm Senator Marilou McPhedran. I'm an independent senator of Canada. And this is an initiative that I have taken in a federal context, but we have many, many leaders to thank, both from civil society and from various political settings, for leadership on this issue of the misuse of non-disclosure agreements. We have roundtable materials that were distributed in advance. Please don't hesitate. If there's any kind of follow-up that you would like from this roundtable, please feel welcome to let us know what it is that you would find helpful, and we'll certainly do our best to provide that. I also want to note that until just a few minutes ago, we did have simultaneous translation provided by the Parliament of Canada. However, the committee needs are what take precedence, and we were just informed that interpreters had to be assigned elsewhere. So this will be in English only. It will be recorded, and the recording will be made available to you. I also, before I turn this over to my co-host, Member of Parliament Darren Fisher, I wanted to acknowledge with great appreciation the leadership and the tremendous contributions made to, not on this issue generally, but specifically for this International Roundtable today, from one of the co-founders of the Can't Buy My Silence civil society organization, represented here today by Stacey and Buchholzer and Liz Leclerc, and to acknowledge, though, that the co-founder, Dr. Julie McFarlane, actually has pneumonia. She authorized me to tell you that as a way of explaining that it's just not possible for her to be with us here today. But of course, she will continue to lead and contribute for, we hope, a very long time to come. And so now, with great pleasure and great appreciation, I'm going to ask my co-host, Member of Parliament Darren Fisher, to say a few words.
Thank you so much, Senator. I really, truly appreciate your efforts, and I truly appreciate your inclusion of me today. This is such a challenging topic, but I do want to let you know that it is a true honor to be here and to listen to experts. You know, to listen to folks with lived experience, to listen to survivors. And I also want to, if I could, Senator, send a huge shout out and thanks to my constituent Liz Leclerc from Dartmouth Cole Harbour for sending me an email and telling me about this and extending an invitation. Your voice and your advocacy, of course, you know, do not go unnoticed. So thank you for all you do, Liz. Today, I see my role as an ally. I'm really looking forward to listening, as I said, to experts, to survivors, people with lived experience. And I said earlier during sound check, and I'll repeat it now, I expect that I'm the one around this virtual table that will come away with the most learning from this roundtable. And I'm just, as I said, thrilled to be a part of this and to be able to learn a little bit more, and I'm thrilled to be with you all today. Thank you so much.
Thank you very much. Darren, I want to just note that for many of the parliamentarians on the Senate side, as well as on the House of Commons side here in Parliament, as you have indicated yourself, this really can't be about a particular party affiliation. This is an issue that spans across all sectors and is missing at the current time in the federal context. And so being able to learn from many different initiatives in civil society and in other political venues, both in Canada and elsewhere. And I want to acknowledge another political leader who's just joined us from Manitoba, Dougal Lamont. You're in the midst of an election, Dougal, so very much appreciate the initiative that you took in your previous session in terms of a bill on NDAs. And as an interesting note that I learned from the Manitoba hearings before the committee, the legislative committee, were witnesses that came before that committee very concerned about confidentiality, and they were able to secure parliamentary privilege for their testimony before the legislative committee. We'll come back for discussion, Dougal, if you don't mind. We have the agenda. We're going to try to follow on this. So my next speaker is actually a representative of Can't Buy My Silence. I also want to acknowledge that Stacey has been the coordinator, helping my office, helping my team make sure that we could bring this together in a timely fashion and reach as many people as possible. And I can truthfully say we're all grateful, Stacey, for your assistance every single day, and we would not be here today but for the very important assistance that you've been able to provide. So thank you, and I'm going to turn this over to you now to talk to us about what the data collected just in the past year tells us about the misuse of NDAs and some highlights from the work of the civil society leader on this issue, Can't Buy My Silence. Over to you, Stacey.
Thank you very much, Senator. A big thank you both again to yourself, Senator, and MP Darren Fisher for co-hosting this event with us with Can't Buy My Silence. And as you mentioned today, Liz and myself will be filling in for Julie McFarlane and trying to fill in her very large shoes. As Senator McPhedran just mentioned, I am the campaign coordinator with Can't Buy My Silence, and I have been fortunate enough to work with Julie and Zelda since the campaign started over 2 years ago. So for the last 2 years, we've been collecting data. Mostly it was qualitative data with many victims reaching out to Julie and Zelda personally, and dozens more anonymously submitting their testimonies, which we published on our website. The sheer volume of the response showed us just how widespread the misuse of NDAs was and is. And now we have the quantitative data to further support and strengthen our understanding of the misuse of NDAs worldwide, not just across Canada or the UK. So our evidence is no longer anecdotal. Numerous US research sources now show that 1 in 3 American workers have signed an NDA. While this number does include intellectual property NDAs, we know that NDAs are most common in service, hospitality, and retail industries where intellectual property NDAs are rarely used. According to our quantitative data, which we developed with partners Speak Out Revolution, whom you will hear from later on in the program, 25% of people who experience workplace discrimination and harassment say they signed an NDA. Another 11.6% say they cannot say for legal reasons, making a total of 37.6%. In one study, 95% of people who had signed an NDA reported negative mental health consequences. Almost 6 times as many women as men reported signing NDAs, which is likely because so many sexual harassment complaints involve NDAs, and because NDAs are widely used when women are unfairly removed from their jobs due to pregnancy. NDAs are also disproportionately used against people of color and people with disabilities. Worryingly, though, 31% report that they did not go ahead and file a formal complaint because they anticipated being asked to sign an NDA. So thousands of complaints of harassment and discrimination are never even being heard because of NDAs and the fear of having to sign an NDA. All of this data and more information are also available on our Can't Buy My Silence website, and I can include that in the chat for anybody who doesn't know it. However, I assume that a lot of you are familiar with that. Thank you, and Liz, I can pass it over to you.
Thank you, Stacey. And yes, I would be one of those women that has experienced significant sexual harassment and assaults in the workplace. So I'm coming to you today, not only as a volunteer with Can't Buy My Silence, but somebody with firsthand lived experience. So to Stacey's point, sexual harassment claims may be directed to any of several possible resolutions routes in the United States. And that's actually where we're pulling some of our significant data from, because there are a number of states now that have passed legislation to ban the misuse of NDAs. A claim to the state agency or to the Equal Employment Opportunity Commission, which is a federal agency in the United States for employees in organizations of more than 15 people, have been collecting a lot of data over the last little while. EEOC claims are a good sample numerically, and significantly more claims go to the EEOC in the United States than to any of the internal state agencies. In 2017, according to the EEOC, there was no NDA legislation anywhere in the United States. Between 2017 and 2020, 6 states legislated to restrict NDAs for sexual harassment cases, and these include California in 2018, Vermont in 2020, New Mexico in 2018, Arizona in 2020, Hawaii in 2020, and New Jersey in 2019. These 6 states constitute approximately 18% of the total US population and almost 10% of nationwide EEOC sexual harassment complaints as of 2021. So in comparing the data, knowing that from 2017 to 2020, it's good to note that in 2017, there was a total of 7,511 sexual harassment claims to the EEOC, and 81% of those were settled. In 2020, after these 6 states passed the legislation forbidding NDAs for sexual harassment, 90% of those were settled. So the argument that's being made currently by a number of government organizations and other groups, including in my own province and here in Nova Scotia, that there might be a decline in settlements after this legislation is passed provincially or federally, does not hold up according to the current data that we have. We know that, as Stacey mentioned, we're talking about individuals in highly marginalized, boundary-spanning roles, and these are individuals that are subject, I see the 1-minute sign, subject to significant harassment. What we want to do today, and hopefully continue to do over the coming time, is counter that narrative that this is going to lead to a decline in settlements. The settlements are not contingent on this legislation being passed. So I thank you for your time, Senator, and thank you for giving Can't Buy My Silence the opportunity to speak here today. And I hope we did Julie justice in stuffing in this morning. Thank you.
Thank you very much, both Stacey and Liz, and indeed, you did tremendous justice to it. I know our time is tight. We have an amazing lineup of very knowledgeable speakers, and so I hope you'll all forgive me for my 1-minute sign and the various nudging that may go on to keep us on time. The next part of our agenda allows me to tell you a little bit about my federal bill. It's S-261. Some of the materials refer to it as a C, which would indicate that it originates in the House of Commons. Not so, but certainly hoping that we can navigate through the Senate process and then introduce it to the House of Commons. In fact, what I'm hoping is that the Senate bill gets stolen by the government of Canada, and that there's a decision to move ahead and create a consistent high standard throughout all of the federal context to protect people and, frankly, to improve workplaces throughout. The bill itself has a bit of a long story. I first started to put together a bill to introduce to the Senate over 5 years ago. And I had tremendous assistance from a number of sources. I would want to single out Can't Buy My Silence as a primary source, but there are many others who, both in civil society and in various political venues, that are taking leadership on this. Not able to be with us today, but a civil society advocate I do want to recognize is Kathleen Finlay. Of an organization, I believe it's Zero, and some of Kathleen's writings can be found in the Hill Times publication. Her analysis is concise, and it is based on personal as well as anecdotal experience from others. My bill, in the end, it changed a lot from its initial drafts. And what I realized as a process of extensive consultation was that really it was a matter of following the money. That if there were any other way of defining the coverage of the bill in a federal context, we were going to be missing entities that received money from the federal government. So that is the crux of the bill. It would, if it became law, it would cut off federal monies to any entity that was accepting that money and not allow that entity. And when I say entity, I mean Crown corporations. I mean federal departments like Sport Canada and all of the different national sports associations that do receive money from the federal government. And in addition to stopping the bullying that occurs in many circumstances, again, in speaking with many different people who have experienced the result of NDAs in their lives, and also given the fact that for a good many years, like decades actually, as a human rights lawyer, I've represented quite a wide range of people who have experienced various forms of harassment and abuse in their workplaces or in their places of education, and also in relation to seeking professional services like help from regulated health professionals such as doctors, dentists, nurses, etc. And in all of that experience prior to coming to the Senate, one of the things that really underscored for me why NDAs can be really damaging was how people described having this hanging over them every day, the impact of having perhaps agreed at the time to being silenced, never appreciating what that was going to do to their daily lives, what that was going to do to their sense of agency as a human being. And the fact that there are numerous examples of a kind of bullying that has occurred where an NDA has been signed, where the person who experienced the harassment and the abuse then sought to have some way of seeking help, including counseling, consulting an elder, for example, speaking to family members, and actually asked for an interpretation. And what they sometimes got back was that they had absolutely nowhere to go and no one to speak to, or they would be breaching their NDA. And that huge limitation that seems to go on forever in many people's lives is part of the stimulus for wanting to make sure that in a federal context, not only is that human agency important, but it is also important for safer, more respectful, more productive workplaces. So in following the money, it becomes necessary for every department in the federal government giving money to any entity to ask those entities, to require those entities to report back on the use of NDAs and on any expenditure both for the creation of NDAs and also the enforcement of NDAs. And it cuts off the federal money for either the creation of new NDAs or the enforcement of past NDAs. And the hope there is that should this become law, that kind of bullying that has pervaded so many people's lives as a result of NDAs would just not be possible. We're going to hear later about the particular role of lawyers in this, so I'm not going to go into it. My last point is going to be about the whole public accountability and the importance of there being transparency as well, and that we already have in place in the federal system the Financial Administration Act. We already have in place the requirement of the President of the Treasury Board and staff of the Treasury Board to gather information directly from federal departments and report out to Parliament as the President of Treasury Board on an annual basis. So my bill, S261, builds on that existing process and adds in reporting requirements all the way up the chain so that Parliament will know what is or is not happening with NDAs and where the expenditure of federal funds occurs. If the bill is effective, that kind of expenditure simply will not be allowed, but it will still be reported out coming up the chain from the various entities that receive various forms of federal funding. Let me close off at that point and open this up for discussion for any questions or comments on my bill. Please feel welcome. I think, Dougal, you had your hand up earlier. May I invite you?
Yes, thank you. Can you all hear me? Yeah, the one point I wanted to make, it's actually, yeah, we put these bills forward, we brought it in again in Manitoba, but the critical thing that people who are considering being witnesses need to know, we did not just obtain parliamentary privilege for this particular hearing. Parliamentary privilege applies for anyone who is ever a witness, anytime. So if you want to show up at any parliamentary hearing or committee hearing, you can break your NDA because that individual who is a witness at committee just during the time they're at committee cannot be held liable. They have the same privilege of freedom of speech that elected officials do because essentially these committees are a form of court. So that's incredibly important. The other is there's absolutely no doubt. I am in an election right now. This is an issue that has not come up, but I also know that I'm being targeted in my riding for bringing it up because because it's been used by Peter Nygaard, who I helped get arrested. It's also been used widely to cover up abuse in the labor movement, unfortunately. And for that reason, that's one of the reasons why I'm being targeted for being to be in my own seat, because there are people who would rather not that I ask the difficult questions in the legislature. So
Dougal, thank you for your leadership on this.
Thank you.
There are many people joining us today leading in this area as you are, I think, who have a real appreciation of the kind of courage that it actually takes to stay with this issue. Can I invite any other comments or questions on the panel? Please just let me know. I'm seeing Rita and I'm seeing Ken. Rita, please. Need you to.
Yeah, I just, hi everyone. I have a couple of questions, but maybe this would help me as the conversation goes on. The use of the term NDA, non-disclosure agreement, I mean, what are the other types of language that people would see? Like I'm thinking about like a full and final release, which is pretty common in a lot of workplaces, but sound like NDAs. Can you help me understand that?
Yes, my response to that is, for example, the Labour Code of Canada makes no mention of non-disclosure agreements. It talks about confidentiality and confidentiality protections. And I think that there's numerous terminology, but we need to look at the content in order to really understand whether, in effect, what is being required in the agreement is non-disclosure, the silencing. And it's the content that really helps to inform whether or not we're dealing with an agreement to silence. The next person with name up is Ken, please, and following that, Suzanne. Ken, could you please unmute? Still can't hear you. Ken, while you're sorting that out, I'm going to move to Suzanne, please.
Got it. I got it.
You got it.
Is that working?
Okay, you're on.
Okay. This looks a little different than the other version of Zoom that I had. Just wanted to ask what we're concerned about, our group, is the use of NDAs in financial services by banks, by investment dealers, when there's been financial assault as opposed to sexual assault. They've lost a lot of money or being mistreated or some fraud even. They're asked to, there might be a settlement. In many cases, they don't even pay when the ombudsman for banking services says you should pay. They still don't pay, but they might offer a lowball settlement. But even those, they require you to remain silent about this, that the whole thing happened and that you, would the bill cover that?
My bill relates to federally funded entities, not 100% funding, but if there's federal money that's flowing to an entity, then the responsibilities of the departments to have that reporting occur is covering all federally funded entities. Okay. So I think on the surface, except where you have a situation where there may be an associated related to financial institutions receiving some kind of funding, but you'd have to show the money. You'd have to establish that trail of federal money going to the entity in question. Suzanne, over to you.
Thank you for the invitation. I have a question about the exception for individuals who have had the opportunity to obtain independent legal advice. I've signed contracts that say you have a week to sign this contract, therefore you've had the opportunity to obtain legal advice. So I would like to hear a little bit more about the choice of this condition as opposed to actually having obtained legal advice. And do you think there's a risk that it could be kind of circumvented by just saying, we give you a week to sign, therefore you've had all the opportunity you need? I'm sure this has been considered, so I'd like to hear more about that clause, please.
In my experience, lawyers are rather brilliant at finding ways around almost any language. So it is conceivable that something, as you described, might happen. However, the requirement of the reporting would hopefully catch situations where there was a signed NDA, and the requirement for the reporting would be to establish that prior independent legal advice was received by the employee or the person who has reported their experience of the harassment or the abuse. Let me also just note quickly on that the actual signing of such an NDA under this bill would be at the initiative of the person who reported and experienced the abuse. And it would nevertheless be a requirement that that person received independent legal advice. And this whole idea that there has to be some kind of exactly the same silencing for all the parties in an agreement like this, there's nothing that says that needs to be the case. So one of the other things that's envisioned here is that you could end up with a non-disclosure agreement that protected the confidentiality of the person who was reporting their experience, and that the way in which the reporting up through the various levels to the President of Treasury Board and in turn to Parliament should be specific enough to be able to spot where there may well be a continuing misuse. I think we've run out of time for this particular part of the agenda. I'd like to now ask Jason MacLean, Secretary-Treasurer of the National Union of Public and Government Employees, to speak with us. Jason, please.
Morning, everyone. And thank you very much for having me. It's truly an honor to be here. And it's I see a lot of people from Nova Scotia here, which is refreshing as well. Currently, I am sitting in Manitoba and had my eye on the election, but we're at a National Executive Board meeting of the National Union of Public and General Employees. So just a little touch on where this all came from for unions to get involved was in my former role, I was president of the Nova Scotia Government and General Employees Union, to where I had conversations with Pink Larkin, and Pink Larkin actually alerted me about what was going on in PEI with the bill being passed in PEI, We found this quite intriguing. As everyone knows, unions are a party to a lot of non-disclosure agreements. And myself, being a Black man growing up in Nova Scotia, I've been discriminated against, felt oppression many times from my employer. I'm a correctional officer by trade. That's where I come out of, corrections in Nova Scotia. And I had agreements that went a very long time, 10 years, and it wasn't finally settled until we signed a non-disclosure agreement, to that I believe the employer isn't admitting any guilt in anything. What they're doing is paying me off and getting and buying my silence, just as we're talking about here. The problem is when people are discriminated against and people are abused in the workplace, they're seldom made whole. No matter what process they go through, they could go through the Human Rights Commission or whatever, but just by virtue of being oppressed, being abused, and being harassed, that person does not come out of the other end being the same. And then we have non-disclosure agreements on top of it, which really makes them feel as such as the system is against them anyway. Yeah, you've been done wrong, but everything still needs to go on. You're not important in this whole situation, and what we need to do is put you aside and move on. And so it really plays into a person's self-importance and mental health as they move forward. I didn't want our union to be a part of that anymore. So with discussions within our union, what we did was we came with a resolution to go to our convention to advocate and to lobby for non-disclosure agreements to be banned as it pertains to sexual harassment, with the thought of branching it out and moving into more. But we felt that we needed to do something, and we felt we needed to protect Nova Scotians and protect our members as well. So when we did that, we entered into conversations with government, and it felt like it was going to be something that was real positive and it would move forward. However, that's something that hasn't happened. And just last year, what I did was I became Secretary Treasurer of the National Union, and in conversations with our National Executive Board and people from across the country, I felt that it was important that NSGU bring this resolution forward for the National Union to take it up, and for us to move forward and work towards the elimination of non-disclosure agreements. So we're very happy to be here, very happy to be advocating for what we believe is what's right. And what we want to be able to do is be a part of this change to make people, to help people be able to tell their full story, to help them to be able to become whole again after dealing with such a thing, and also to never have employers cover up for anybody and really want to move forward and promote decency within the workplace, and to have people just move forward and live their best life without any type of system that really has their foot over them. So I wish I had more time,
Jason.
But thank you very much. I appreciate it.
I wish we could give more time as well. Very much appreciate your remarks and your taking the time to be here. We're going to hear next from Kim Shore, who is the co-founder of Gymnasts for Change. Before Kim speaks, though, I want to just quickly acknowledge with great appreciation State Auditor Dianna DiZoglio, who I see has joined us and who will be speaking right after Kim. And so over to you, Kim.
Thank you, Senator. It's no secret that NDAs have been misused in sport to cover up abuse, harassment, discrimination, and many forms of oppression. They lurk alongside complicity, corruption, and violations of human rights. NDAs in sport involve an imbalance of power because, contrary to popular belief, athletes are not the power holders in sporting scenarios. Furthermore, these silencing mechanisms disproportionately affect sport participants with intersecting vulnerabilities of race, sexual identity, gender identity, socioeconomic status, age, and capacity. In sport, exploitation of vulnerabilities is pretty much customary. A case-by-case approach must be applied, though, because there are situations where NDAs function to protect victims, but this must be at their request, not imposed. Too often, NDAs shield sport organizations from public scrutiny and enable predators to move from club to club, sport to sport, repeating their inappropriate behavior, leaving a trail of otherwise preventable trauma behind. All forms of silencing leaves future generations at risk. The world of sport is autonomous and self-policing. Silencing those who dare to challenge the status quo or disrupt those in power is abetted by NDAs which take on many forms. For instance, athlete contracts. Athletes have to sign these agreements to participate in sport leagues, sanctioned events, or to be selected for a national team. Signing these standardized contracts is done with no bargaining power and essentially under duress in exchange for competitive opportunities and funding. Signing is a complete loss of power for the athlete, whereby they actually become the property of the organization. Speaking out against their sport federation for any reason is strictly prohibited, and retaliation is real for those who try. Another example is confidentiality provisions. These are included in the complaint policies across sport under the guise of protecting the case. The result is to keep victims quiet and protect sport's preferred reputation of being inherently good. Forced silence compounds a victim's shame and isolates them from their trusted support systems. The explicit threat that a complainant will tank their case if they share their experience sabotages the possibility of uncovering witnesses who might corroborate their story and prevents additional victims, because there's never just one, from coming forward. No external scrutiny also means these processes can drag on for years, which in and of itself is a mechanism of oppression. And even after the process is complete, a victim's ability to speak is at the behest of adjudicators who have full discretion to determine who is allowed to know about the disciplinary action. Punishment for a victim speaking out can come at the cost of their athletic career and their personal safety. The notion of fiduciary duty is also misused to silence board members who are told over and over their obligation is to protect the organization, that bad press for the sport organization is worse than any abuse. Boards and staff are told that maintaining a positive brand will increase participation, which of course will generate revenue, but it also conceals the darker side of sport. Repeatedly, sport organizations quietly remove abusive individuals with messaging to the sport community that they resign for personal reasons. Without transparency, that individual is free to coach in other communities, and unsuspecting sport clubs and parents have no idea that they've just hired a dangerous, prolific predator to coach their children. Again, transparency about wrongdoing is sacrificed to maintain the image that sport is good. Lastly, it's not uncommon for traditional NDAs to be used with personnel who are relieved of their duties. This includes whistleblowers who were fired for challenging wrongdoing, negligence, and inconsistencies. Often, they are required to sign NDAs, sometimes called releases, in order to collect severance pay that is rightfully theirs. Non-disclosure agreements and non-disparagement clauses should never be used to prevent sport professionals from disclosing maltreatment they have experienced or witnessed.
Thank you, Kim. I'm sorry I think you had a few more words to say, but I hope you'll have a chance to come back to this in the discussion. Thank you for your leadership, Senator. And thank you for making the time to be with us today. Our next speaker comes to us from Massachusetts, and she is the state auditor of Massachusetts, also served as a state legislator, and in over a course of many years, Dianna DiZoglio has been a clear leader on accountability and transparency in many forms, including the misuse of NDAs. I'm truly grateful on a personal basis, Dianna, that you and your team facilitated your being with us today, and I'd like to turn the floor over to you at this point. Thank you.
Great. Thank you so much, Senator McPhedran, and to Julie and Stacy and everybody for the gracious invitation to join you today. It is my humble honor. My name is Dianna DiZoglio. I am the state auditor for the Commonwealth of Massachusetts in the United States. And it is great to be among so many advocates today. I am going to simply share my personal story in the hope that it can uplift this very important issue regarding the misuse of non-disclosure agreements. I was born to a 17-year-old single mother. I was raised housing insecure. I ended up moving around quite a bit during my childhood, depending on where my mother could find work. I ended up graduating from public school and going off to community college, which was an associate's degree I was able to afford thanks to our state's investments in families like mine. I then got a scholarship to attend Wellesley College and become the first in my family to graduate. I ended up soon after that getting offered a job working in the Commonwealth of Massachusetts at our own state house as a legislative aide to a state representative in the state legislature here. In only a matter of months, unfortunately, I was sexually harassed during my time working at the state house in Massachusetts. And the way that they thought it was appropriate to make that sexual harassment stop happening was to fire me and then require that on my way out the door, I sign away my right to talk about literally anything I had seen, witnessed, or experienced by signing a taxpayer-funded non-disclosure agreement. But I didn't let them get rid of me. I didn't let them keep me quiet, and I didn't leave state government like they told me to do. I instead decided to run for state representative myself, and a little over a year later made my way back into that same chamber that dismissed me as the youngest woman serving in the House of Representatives at that time. Subsequently, I ended up running for state Senate, where I served as the youngest woman serving in the Senate, and I am currently now the youngest constitutional statewide officer in the Commonwealth of Massachusetts. And through the last several years, during my 10 years serving in the state legislature and my under a year serving as our Commonwealth's new state auditor, I have been alongside of advocates just like you, fighting to protect potential victims of harassment, discrimination, and abuse of any kind from these required non-disclosure agreements, whether it be by state entities, government entities, or by the private sector. As a state legislator, I worked hard to ban their use in state government and to ban their abuse in the private sector for these types of instances. And now as state auditor, I'm working hard to uncover how much in our tax dollars in the state of Massachusetts has been used to silence public employees about harassment, discrimination, and abuse that might be occurring. My office is currently conducting an audit of state entities across the entire Commonwealth of Massachusetts to see how many times these non-disclosure agreements have been used in recent years, what they've been used for, who they've been used for and by, and also to make sure that we have an understanding about how much in our taxpayer dollars is being used to cover up these abuses in government, but also protect powerful perpetrators of these abuses. It is unacceptable. It is beyond past time for change. And I am incredibly grateful to you, Senator, to Stacy, to Julie, to this entire contingent of folks we see on this call today for your advocacy and work on this important issue. And I look forward to working alongside of you in the years and months to come. Thank you so much.
Thank you, Dianna. I find as a parliamentarian that I'm sitting a little bit in awe of the various ways in which you have taken leadership positions. You have been supported through public elections, and you have held the course on transparency and accountability. And I have a hunch that what you do as state auditor is going to go down in the books as being a very significant shift in what state auditors can and should be doing. So it's with very deep appreciation that I express my thanks for your taking the time to be with us today. And I hope you can stay on for the question and discussions part, because I'm sure there will be many to all of the speakers here today. One of the comments I made earlier was about, as a lawyer, was about lawyers. And the truth of the matter is we wouldn't be here today talking about the misuse of non-disclosure agreements if a large number of lawyers all over the world had not increasingly started to use them in settlements and agreements where they just 20 years ago, they just weren't being used in this way. And I was frankly surprised, pleasantly surprised, when the Canadian Bar Association passed a very strong resolution that really called lawyers to account and gave them the opportunity to start to step away from seeing this as an acceptable practice. And I now want to recognize and ask to speak Joanne Stark, who proposed the, to me, somewhat surprisingly successful Canadian Bar Association resolution on non-disclosure agreements. Joanne, please, over to you.
I'd like to thank the Senator for extending the invitation to attend today. I'm pleased to be speaking to you today from the unceded and traditional territories of the Musqueam, Tsleil-Waututh, and Squamish Nations in Vancouver, Canada. Throughout my legal career, I've always been a very strong supporter of access to justice and making sure that people have an opportunity to be heard. However, I've noticed that over the decades, the use of non-disclosure agreements has become increasingly routine in many types of agreements, as the Senator alludes to. Now, non-disclosure agreements, or NDAs, are designed to protect trade secrets in commercial transactions. They're signed for the specific purpose of ensuring that business information shared remains confidential. In other words, they're designed to protect organizations to prevent trade secrets from being used by competitors. However, as a lawyer, I began noticing that these NDAs were being used not only to protect commercial trade secrets, but also to silence people who brought forward any claims of harassment, wrongdoing, or discrimination within organizations. Now, there are two reasons why this is a problem. The first is that it causes more harm to the person who has been wronged. Too often, these victims or these whistleblowers are required to sign an NDA before an investigation even begins. And this prevents them from speaking to family, to friends, coworkers, therapists, to even explain what has happened to them. In a sense, these people are being re-victimized, and some find it very difficult to get the help and support that they need to begin that important healing process. Now, they say that there's a saying out there that suffering is a choice. Well, I would argue that it isn't a choice if you're forced to keep an ugly secret to protect an organization and to protect somebody who has caused you harm. NDAs take away that choice. So the suffering may continue, often by just keeping silent. And when a legal tool goes from being a shield to a sword, legal professionals need to stand up and take notice. Once that line is crossed, you can start seeing many organizations and many lawyers randomly placing NDAs all over in agreements and forms, places that have nothing to do with protecting trade secrets. So that brings me to the second negative impact of these NDAs, and that's that the perpetrator of the harassment is essentially the one who remains protected. This means the offensive activity often continues, and more people could potentially be victimized by this individual. The organization is often more concerned about protecting the perpetrator, who often has a higher level of responsibility in an organization, than the person who has been mistreated, who's often a lower level employee or maybe even a volunteer in the organization. And sometimes these people are even our children, our youth who are victims of abuse or assault in the hands of adults in power within sporting or youth organizations that receive funding from governments. Too often the impact of these NDAs is that a toxic culture is allowed to continue, often even for decades. In February of this year, I brought forward a resolution to the 36,000 lawyers and judges who are members of the Canadian Bar Association to prevent the misuse of the NDAs. And this resolution was passed by 94% at their annual general meeting, with a strong show of support to have members lobby for legislative changes and to ensure legal professionals gain a better understanding of the potential negative impacts of NDAs. When we know better, or when we do better, we know we can do better when we know more. So since lawyers are often the gatekeepers who draw up these legal agreements and documents, we need to be more aware of the impact of these actions. Since then, we've seen lawyers come together across the country to advance advocacy initiatives to promote new legislation, provincially and federally, legislation that will ensure victims and whistleblowers are no longer silenced. And in my view, this represents a positive shift in culture as legal professionals are prepared to step up and be a part of the change that's so desperately needed. And I want to wrap up with a more personal story here. I grew up in the small city of Swift Current, Saskatchewan, which faced its own shameful reality when several junior hockey players that played for the Swift Current Broncos, many of whom were classmates and friends of mine, came forward with stories of sexual abuse in the 1980s. This was a coach who was able to enjoy a lot of success, so there was an added incentive to hide the abuse and disregard allegations that were brought forward. Even more tragically, this very same team suffered a tremendous loss as several teammates were killed on the highway outside the city in a bus accident while going to play hockey. And I'll never forget that day, nor will the community. These hockey players have suffered for many decades and continue to deal with the aftermath, as do their families. They deserved better. They deserved to be protected. And yet it took years before justice was served, years before victims of sexual abuse were even heard. The more we as a society condone this and just cover up for those who use power and persuasion to carry out such abuses, the more it will continue. So we have an opportunity now to do better, to be better people. I'm proud to see the legal community stand by me in this initiative and to lobby and advocate for stronger legislation to protect people who report wrongdoing, such as the bill brought forward by Senator McPhedran. And I want to thank you for the opportunity to speak today.
Thank you very much, Joanne, and thank you for your leadership and your initiative. It's had a tremendous ripple effect already throughout the legal profession. I will just, before introducing our next speaker, Julie Roginsky of Lift Our Voices, I just wanted to share that in our first international roundtable that we held last year, almost exactly a year ago, one of the legislators from California made the point that it was crucial to reach out and address this issue with lawyers, with the legal community, and that sometimes it was necessary to lay out the ways in which lawyers can make the situation much worse through legal means, of course, and to really call them to account. And I think that is what we're seeing, a kind of shift that occurred earlier on this issue in some other parts of the United States. We are seeing that shift happening here in Canada, and it's indeed very welcome. I'm very pleased and very grateful to be able to introduce now one of the leading advocates in the United States on this issue of dealing with the misuse of non-disclosure agreements, Julie Roginsky of the civil society organization Lift Our Voices. Thanks so much, Julie, for making the time to join us. Over to you.
Thank you, Senator, and I'm so grateful for the opportunity to speak to you today. As you mentioned, my name is Julie Roginsky, and I'm one of the co-founders of Lift Our Voices, which is a United States-based organization dedicated to eradicating silencing mechanisms such as non-disclosure agreements in the workplace. I want to take a few minutes just to provide you with some personal background about the pernicious effects of NDAs and to explain the action that my organization took to ensure that more Americans and everybody around the world can speak out freely about their workplace experiences. Along with my Lift Our Voices co-founder, Gretchen Carlson, I'm one of the women who sued Roger Ailes, the former chairman and CEO of Fox News, for sexual harassment and retaliation. At the conclusion of our lawsuits, Gretchen and I were both bound, as were many other women, by a non-disclosure agreement that prevented me from ever discussing what happened to me. Other people have purported to tell our story, Hollywood, the media, countless authors, and yet we, the women who endured this behavior at work, are perpetually silenced about one of the most traumatic incidents of our lives. This is wrong, and we decided to do something about it. As you may have heard, the United States is highly polarized at the moment, and yet by working across the aisle over the course of several years, we were able to persuade enough members of Congress and the Senate to overwhelmingly pass our law, the Speak Out Act, which bans NDAs for pre-dispute sexual harassment and assault. So today, as a result of this law in the United States, no one can bind a survivor of sexual misconduct to silence when the bad behavior occurs. This is a watershed moment in the fight for a more transparent workplace, and it is one that is taking place not just in Washington, but at the state level as well. 3 states, New Jersey, California, and Washington State, have passed bans on NDAs for all toxic workplace issues, such as harassment, discrimination, and retaliation. And the effects have been astounding. When Washington State passed its ban, for instance, Microsoft, which is based in Washington, decided to eradicate NDAs for all its employees worldwide, not just for those living in Washington State. When California passed its law, Apple, which is based in California, did the same for all its employees around the world. So if you're in Canada and you work for Microsoft or Apple, you are now banned. You are no longer bound by non-disclosure agreements. in your workplace. We at Lift Our Voices are looking to bring similar NDA bans to New York, which is such a worldwide economic hub that a state ban would have massive impact around the world, and to states like Connecticut, which are a major hub of finance as well. Just to give you some perspective on the effects that these bans have had, New Jersey has had a ban for the last 4 years. We recently concluded a study of that now 4-year New Jersey ban. We're about to release it publicly, but I'll preview it for you here today.
Yeah.
This study shows, excuse me,
I didn't call, no.
that there's been absolutely no negative impact on businesses in banning NDAs for all toxic workplace issues. Crucially, it also shows that a ban had zero impact on survivors' ability to settle. So no negative impact either from the perspective of a settlement or from the perspective of an organization that previously instituted this ban. A ban on NDAs for toxic workplace issues just simply improves worker morale and productivity. It allows women, people of color, members of the LGBTQIA community, differently abled workers, and others who've been traditionally disenfranchised to go to work with dignity. That's all it does. It would allow organizations to identify predators and to hold them to account. It is simply the right thing to do. And I thank you so much for the opportunity to speak to you here today.
Thank you, Julie. That is an inspiring overview of change, substantial change over a relatively short period of time. For those of us on the call who are parliamentarians and legislators, we know what a relatively short timeline you have just described. And of course, it's the advocacy that is brought to this issue and the kind of informed evidence that is set out over and over again by advocates that is starting to make a real difference. This concludes part 2 of our discussion, which was looking at NDA policy and policymakers. I was not able to secure the participation of Sport Canada, but I did want to give a shout out to the staff, the officials at Sport Canada. We have a new minister there, Minister Qualtrough, who's actually returning to the portfolio. And I think it's important to note that while we may consider changing law, I certainly do, as being the most effective way to address the issues that we are hearing about today, it is also possible to have policy changes. And I do want to recognize that in response to the very many very serious cases that have been revealed in Canada over the very recent time, that there has been quite a significant change in Sport Canada with the policy around what is required of any organization receiving Sport Canada funding to try and increase the accountability and the transparency of those organizations and to ban the use of NDAs except as related to I guess you would say, trade secrets of sports. And while I want to be very positive about that, and I am, I also want to recognize, though, that leaves us, nevertheless, with a patchwork within the federal context, and that very seldom do we see a consistency of policies across the vast array of entities that receive federal funding, and that underscores, on one hand, saying, good that we see this development, but even better to have the consistency, the reliability, and the assurances of moving this into legislation. As we move to part 3, we're going to open a discussion on strategizing and challenges in moving forward. And this is a discussion for question and answer, but we're going to begin with discussants who have been invited to make particular comments, and they will be brief, but I think they will help to build the platform for our open discussion to immediately follow. So I'd like to now welcome as a discussant to us, Ron Pink. You can see the Pink Larkin Lawyers and Avocat sign behind you, Ron, and over to you. Thanks so much for being with us.
Thank you, Senator. It's a pleasure to be here with all these distinguished guests. When we talk about strategizing, this is a matter for public interest and politicians. The best case in point is the little province of PEI. PEI is the only province in the country who has a clear law that prohibits NDAs. It arose sometime in the late teens, and it comes as a result of a variety of things. But one of them was an issue at the University of Prince Edward Island where two women were sexually harassed by a senior official in the university. They signed an NDA. This is back in 2012 sort of time. And not surprisingly, the person who perpetrated against these two women continued to perpetrate against other women for a period of 10 years unabated. And the university knew that this was going on. The Board of Governors knew this was going on and did nothing about it. They knew the first claim because they had authorized the payments. And they did nothing to check or investigate what was going on in the meantime. A clear governance problem in that situation, which they regretfully still to this day don't acknowledge. So it's the classic case of an NDA allows a perpetrator to perpetrate, and they continue to do it unabated and unrestrained until this year or late last year. It came out to light again where he had been going on with an individual been going on harassing women for up to 10 years, and he got caught, called out, and the situation changed. But one of the effects of not dealing with this situation by the employer was the disease that was created inside the university. It is profound. And Reuben Tomlinson did a study report, which is very extensive, categorizing how the sexual harassment just undermines an organization. Same thing with NDAs. It allows the organization to fester in the cesspool of disease. Can't do it. We have to stop it. And I just say one other thing. Why don't we amend the Canada Labor Code to make NDAs illegal in any federal operation as well? Thank you.
Having the perspective of a long-standing practicing lawyer added to the discussion. The next discussant I would like to ask to join us is Richard Moorhead, please. Richard.
Thank you very much. Can you hear me?
Yes, indeed. I hear you.
Excellent. Thank you. I speak from England. I'm a law professor in England who has spent some time looking at non-disclosure agreements prompted by Zelda Perkins' case way back in the mists of time, it feels like now, and somewhat inspired by Zelda's example to follow up on some of the issues. I guess I'll just say a couple of things about the issues in the UK as I see them. Zelda's case prompted me to write a blog about her agreement, which suggested that actually what the lawyers were doing when they were writing non-disclosure agreements of the kind that Harvey Weinstein's lawyer had written for her is that they were effectively perverting the course of justice, whether they saw it that way or not, because they were trying to silence Zelda both in relation to her case and her colleague's case, but also to stop her talking to other people who might have similar problems. And we've seen examples. Harvey Weinstein is one example. We had an example recently, Russell Brand, where a lot of those cases are rumored to be subject to non-disclosure agreements, and we'll see if that's true. I'm expecting over a period of time. The government hasn't been willing to regulate. It's sort of talked about regulating in the area without really making any serious moves in that direction. The professional regulator, which is the Solicitors Regulation Authority, they're sort of independent of the Law Society, the legal professional representative body. They issued guidance, which was initially quite well received, and that tries to discourage lawyers from writing NDAs which stop people reporting matters to regulators or to the police, and tries to discourage lawyers from, if you like, taking unfair advantage of, is the actual phrase in the rules, taking unfair advantage of their opponents, people like Zelda and so on, who are subjected to these non-disclosure agreements. That guidance, I think, prompted quite a strong debate in the profession, some of which was taken seriously by some law firms and some lawyers, some of which prompted a sort of a bit of a backlash along the lines of, we're here to provide our clients with rights, and if they have a right to a non-disclosure agreement which protects their reputation, then that's exactly what we will do. And I would say the jury is pretty much out on whether that guidance has really affected behavioural change. What I think would also make a difference is enforcement, and there have been 1 or 2 cases of enforcement. So Weinstein's lawyer, there was a case brought against him which eventually stalled on medical grounds. It was being defended by the lawyers, a guy called Mark Mansell, partner at Allen & Overy. But since then, we haven't really seen, as far as I can find out, any serious attempts to enforce on even egregious non-disclosure agreements. And that strikes me as a bit of a curiosity now, given the passing of time since Zelda's case. So I guess my point is, professional regulators can do things, can try to do things, but they've so far had quite limited success in terms of what they've attempted, at least in the UK.
Thank you very much, Professor Moorhouse. That lends very strongly to the nature of this discussion being international. And I would also just like to acknowledge with thanks Zelda Perkins, whom you mentioned specifically. Zelda is a co-founder of Can't Buy My Silence with Dr. Julie McFarlane. And so you have given us additional information about the kind of experiences that lead to this crucial advocacy that parliamentarians rely on. We need to have this kind of partnership with civil society. Marie, you sent a note saying that you may be having some difficulty with your signal, but let's give it a try. We'd love to hear from you. I'd now like to invite Marie Hemingway to join us.
Thank you. Can I confirm you can hear me?
Yes, so far.
Hello. Oh, fantastic. So good afternoon from the UK, everyone. Just to make you aware, I am traveling on an overcrowded train in the UK and my connection is dropping in and out, but I was desperate to be here and to support this conversation. So I will do my very best. Please move on if you can't make sense of what I'm saying. By way of introduction, my name is Marie Hemingway. I'm the Chief Technology Officer for Speak Out Revolution. We are a non-profit who are on a mission to cancel the culture of silence on workplace harassment and bullying. We do that through hosting a global anonymous survey where we capture or empower people to speak out about their experiences anonymously, their route to resolution, and the outcomes that they achieve in organizations globally. We, I think, particularly support legislative change in the NDA or mechanisms of silence space, because we can see that they are essentially the legal epitomization of the challenge that we see in workplaces, which is the systems that are set up, the best practice systems and processes that are in place globally, do not support resolution of people who experience workplace harassment and bullying. They essentially silence them. And so any change in the legislative space we see will support change and will enable us to cancel that culture of silence.
Hey, we just hit a signal problem there. I don't know if you can hear me, Marie, but we can't hear you. I'm going to accept your invitation.
Violet, Can't Buy My Silence fan.
Let's try again.
Hello.
Hi. We missed you for about the last 10 seconds, so if you wouldn't mind, maybe you could try to pick up.
Apologies. Just a thank you to the Can't Buy My Silence campaign, who are taking our analytics and turning that into action. Thank you, Liz. Thank you, Stacey, for representing on this call, and thank you, everyone, for joining. I think my query or question that I will put to this group is, how do we ensure
Marie, do you have the capacity to type into the chat and then I can read out your question? because we lost your signal just as you were about to set out the question.
The outcomes that we want to achieve. For us at Speak Out Revolution, it's changing the 1 in 4 people who sign NDAs or are silenced via some mechanism to 0 in 4.
Thank you very much, Marie. And if you are able to type into the chat, we're very happy to share some of your comments that were cut out by the signal. It's a testimony to your commitment that you did your absolute best to be with us even as you're jostled along on a train. So thank you so very much. And now we come to a more open part of our time together today. We have about 10 minutes for questions, comments, and I'd like to open the floor up for anyone who would like to step up and use this time. Rita.
I should probably identify who I am beyond my name. I'm a journalist in Canada, long time, 32 years with CBC. So I have a couple of questions, but given the time constraint, I'll ask this one. Because in the absence of legislation today, how could one demonstrate the misuse, the broad and systemic misuse, of NDAs? I'm struck by the story, I think it was Ms. Roginsky, I might have that wrong, talking about how, it's the audit of taxpayer money and how many NDAs were used, how much money, valuation. So I think I've identified the wrong person, but if anyone can weigh in there, as a journalist today, how could I go about tracking enough systemic action to display how misused it is?
I'm going to ask the response to that to begin with State Auditor Dianna DiZoglio, please.
Sure. Happy to jump in here, and thanks for the question. So I had spoken about how I was a state representative and a state senator. I served in our state legislature in the state of Massachusetts in the United States for 10 years and fought hard during my time there to ban the abuse, to ban non-disclosure agreements in state government and to prevent their abuse in the private sector. It's my strong belief that tax dollars should not be used to silence victims of harassment, discrimination, and abuse. Legislative leaders in the Commonwealth of Massachusetts have actually been pushing back tremendously against my efforts to pass this legislation. Not everybody, but enough to block the bill's passage. And during my time in the legislature, I was not able to get the bill past the entire legislative body to the governor's desk. Now, during my time as state auditor, I am using this platform to conduct this audit of how much in our taxpayer dollars are going towards funding these silencing agreements and how much is being spent to cover up potential harassment, discrimination, and abuse in the public sector. I find it to be one way that we can shine a light, so to speak, on how these agreements can be abused across the board and how pervasive they actually are. And as we've been conducting this audit, though I can't share the details of the audit until we're complete due to government auditing standards from the Government Accountability Office here, I can say that as we've been conducting this audit, we have had many folks come to us and let us know about the abuse that they have experienced in the workplace, the fact that they were given silencing agreements, that they were required to sign a non-disclosure agreement. And this is certainly one tool that can be used to help identify how prevalent and how pervasive the abuse of these agreements might be, at least in governments, the government's eyes. So I am following an audit model from the state of Montana, where Montana actually conducted a very similar audit, and they were very successful in helping to actually provide that information to lawmakers and to their administration. And they saw a tremendous decrease in the amount of non-disclosure agreements that were used in government after the audit was released, because they set up a process where there was accountability now required for every time someone gave out a non-disclosure agreement. There was no longer allowed to just be this free-for-all where NDAs could be handed out like candy and nobody knew why, when, how, or who they were being given to. So I highly recommend it. I am facing tremendous pushback from leadership that's elected in the legislature right now. I am trying to conduct an audit of our state legislature. A look at these non-disclosure agreements is actually part of that audit. And our legislative leadership in the state of Massachusetts is actually the only state entity that's refusing an audit by my office. We are pursuing litigation through our Attorney General's office. And actually, I'm pursuing a ballot question alongside of this. So we're going all the way. We encourage you all to keep doing the same thing because transparency is absolutely needed when it comes to the abuse of these agreements and how they can be used.
Thank you so much for that comprehensive answer, which I would boil down to your comment, we're going all the way. The importance of staying the distance, the importance of understanding the distinction between changing a law, changing a policy, and actual implementation, and keeping the focus on the damage that is done by something like this. Marie was cut off from the question that she wanted to pose, but I now have it through the chat. How do we assure ourselves changes in legislation can change our global statistics from 1 in 4 people silenced by NDAs to 0 in 4 people silenced? Let me invite comments and responses to that. Whoever feels they would like to jump in with a response, that would be great. Judith. Dugald.
Hi, sorry, I just had a question rather than a response. Would your legislation cover people who are forced to sign NDAs for whistleblowing reasons, such as reporting corruption or incompetence or just acting out of the public interest? Or is it restricted to harassment and violence?
It is defined in terms of the Labor Code definition of harassment or violence in the workplace. We're looking very closely at the whistleblower aspect because when my bill was drafted, there was a review going on by Treasury Board on this very question of whistleblowers. I think we've now seen that that has not had either the traction or the results that one would consider acceptable. And so hopefully my bill will get to committee, and hopefully we will be able to look at a substantive amendment on whistleblowers. May I go to Dugald now, please?
Yeah, just a note to Rita Celli. Look, we have 5 hours of testimony about NDAs, 20 minutes at a time, that took place, I guess it was last November. And it was shocking. Every single story was absolutely appalling. It happens in every single everywhere you can imagine. It's happening in corporate Canada. We talked about Peter Nygaard with NDAs. We had a police officer, universities, teachers, everyone, unions. There was no exception where this is not happening. But I have to say, the reason I came to this was because there's been a very serious problem in Winnipeg with the cover-up, not just of sexual harassment, but sexual assaults. There have been actual crimes being covered up, and that victims, and I have spoken to so many people who are broken because not only have they been abused and sometimes assaulted criminally, the very organization that's supposed to protect them is the one that is making it worse and attacking them, pretending and ignoring them and denying them justice. And I am the only political leader ever to stand up and talk about this ever in this province. And I know I'm being targeted about it because we cannot get anyone to talk about it. We cannot get people to write about it because the complicity, the conspiracy of silence is so bad because the people involved are so powerful.
Thank you, Dugald.
I'm talking about people at the very
Thank you.
top
I really appreciate your comments, Dugald, but I'm going to ask now if we could please move on.
It is not being taken seriously. Yeah,
thank you, Dugald. Thank you very much for your courageous leadership on this. Joanne, and after Joanne, Jason, please.
Yeah, it's just a response to Marie's question about how we can change the global stats. Obviously, when you update legislation, that may have an impact in specific areas and specific regions. But where the real impact happens is that as you have more and more pieces of legislation rolled out, is you're going to see those policy changes within organizations. And I think there was mention of Apple and Microsoft and things like that, where global entities that have employees throughout the world, or organizations that have volunteers throughout the world, start changing and updating their policies internally, so that this is not something that they will want to adhere to. And that's more pressure from reputational risk. So organizations are not going to want to be the ones that are the outliers that don't follow these rules or don't follow these policies. They're going to want to get on board and be seen as employers or organizations that protect people from wrongdoing. And so that's where you're going to start to see the changes globally. So it's going to take time, because as more and more pieces of legislation are introduced and policies have to be changed within organizations, that's where you're going to start to see a global shift. As with any type of legislation, you see those shifts happen culturally within organizations down the road.
Thank you so much, Joanne. Before I ask Jason to speak, I'm going to ask that we can bring some expertise from both Jason's perspective and also Kim Shore as a co-founder of Gymnasts for Change, in that I made a comment about the policy that was reported to me by officials at Sport Canada. And I think it's really important. I'm not an expert in that area, but we have an expert with us. And so I'm going to ask him if you wanted to respond to that or any other aspect, because I unfortunately had to ask you to limit your comments. And I'd like to invite you back into the discussion as an expert on this. And then Jason, if you would comment as well, please. Over to you, Kim.
Thank you, Senator. I would say that at the moment, harm is being perpetuated by the sport ministry, and that is a bit of a legacy to the last minister. This patchwork approach and stonewalling of a national inquiry into sport actually allows Canada and Canadians to gloss over getting to the rot of the sport system's corruption. So by making small micro fixes, it actually silences advocates, silences victims to say, well, we can't say anything anymore because they're making all these little fixes, but they're actually not getting to the heart of the issue. And it's the harm will perpetuate because we haven't changed anything about the structure. Thank you for that opportunity.
Well, and thank you for that very important clarification. I'm not usually seen as a Pollyanna, but on this one, I just might have been for a moment. So thank you. And over to you, Jason.
Thank you very much, Senator. Just a couple of comments. One, for Marie's question, one thing that Marie said is that Marie's not going to stop. It's going to keep going. And that's what needs to happen. And I absolutely agree with the other speaker as well, that once you build policy and once you get it somewhere else, then you have the door open and you can move it along. So I believe it's a lead by example type of situation, and other organizations will want to get on with it. But they need to see the way as well. So other people need to do it. So thank you, Joanne, for your comments as well. Earlier, I had mentioned that unions are part of non-disclosure agreements. Well, in the function of a union, what it wants to do is get something for its members. And what we look at with a bill such as yourself, such as you have put forward yourself, is that helps us to get out of that circle of non-disclosure agreements, because once they're no longer an option, it's something that will not be used. The pure function of people is trying to make somebody whole, and we cannot do that, I believe, through non-disclosure agreements. So we got to have difficult conversations, and we got to be able to come to a solution. So I really appreciate everything that you're doing here, and I'm very pleased to hear from everyone, even more so when I've heard from them all. So thank you very much.
Jason, that's a very nice way to segue for us to close this discussion. We just have a very few minutes left, and I am not seeing more hands up. I do want to say that we've had some really substantive comments and information shared in the chat. And so as part of our record of this international roundtable, we will also be capturing the information and the comments in the chat and making that part of what is available to be shared, so that our conversation will happen today, but hopefully will become a very helpful resource in many ways for the future as well. And I also want to give a thank you to my sister senator from Manitoba, Gigi Osler, who has been with us throughout this discussion. And I know that a number of senators' offices have their teams on as well. Hi, Gigi. Thanks for joining us. As we close, I don't want to put you on the spot, but I wondered if there was any kind of a comment you might want to make. I would like to acknowledge for everybody on the call that Dr. Osler was the first racialized woman in the history of Canada to be the president of the Canadian Medical Association, and that she led on the first ever diversity and equality policy for that very important organization. Senator Osler, any comment?
Thank you for that kind introduction. Can everyone hear me?
Yes, we can.
My only comment is one of gratitude for the information and stories shared here today. And thank you, Senator McPhedran, for organizing this very informative roundtable. Thank you.
In turn, I have to thank a whole large team that made it possible. And I think that, as happened a year ago, we've created a very important international record to add to this long-standing and forward-looking campaign that is now, we can really truly say it's an international campaign to ban the misuse of NDAs. I'm going to turn this over now to my co-host, Darren Fisher, for any closing remarks you'd like to make, Member of Parliament Fisher.
Thank you so much, Senator. First off, I just want to say I've been on a million of these Zooms, and I've been in a million committee meetings. I've never seen better agenda management by a chair than what you've exercised. And I have to tell you, Senator, I really got a chuckle out of you getting buzzed by yourself when you went a little too long in some of your comments. That was one of the many highlights of this truly international roundtable. We've got people speeding across the UK on a high-speed train. We've got, this is absolutely amazing. And you said when Ms. DiZoglio was speaking that you were in awe. I was using the exact same word. I was in awe, but I was also in awe of Ms. Stark, Mr. Pink, Liz, Stacey, Kim. I'm an optimistic person, and I see this as a glass half full. I see these walls coming down because of the work that the people in this line are doing, notwithstanding Ms. DiZoglio's comment about the pushback that she faces and Dugald's comments about the pushback that he gets. I see, again, looking at this as in an optimistic focus, I think that we will get to the places that the experts and the folks with lived experiences on this call are speaking about where we need to get. And it doesn't seem like the road is going to be as easy as some people have. Again, going back to Ms. DiZoglio, what she has accomplished is absolutely amazing. Can't solve the problem? Run for office, figure it out. Absolutely incredible to be a part of this roundtable. Thank you all for your comments. I thought I would be the one that learned the most. I suggest I probably was. Thanks again for including me.
Thank you. And in my closing comment, I just would like to acknowledge that I am wearing an orange shirt, that senators are about to have a collective picture for September 30th, which in Canada is the National Day of Reconciliation, to both acknowledge and atone for the many injustices directed at our Indigenous peoples in this country. And my closing statement is to have as a land acknowledgement that the Parliament of Canada is situated on the unceded, unsurrendered lands of the Algonquin and Anishinaabe peoples. Thank you again. Very much appreciated that each one of you took the time and contributed so substantively to this, and the record will be available to all of you, and I know it will be helpful. Bye for now. Stay safe.
Thank you.